Can I be heard at the back? Thanks for the introduction, Simon. So my talk tonight is on the evolution of private cooperation. What are the mechanisms that have allowed people to conduct undertakings together that involve necessarily having more than one person? So some of you, and I know Brian Micklethwaite will be one of them, will be familiar with the work of Alan McFarlane, and I'm sort of representing some of the stuff that Professor McFarlane has drawn from the work of a guy called F.W. Maitland, and also some ideas that have come from someone called Timur Kuran, who's a Turkish anthropologist and economist. So what this is to do with is how people can work together, and how is it that people can trust strangers, people they don't have blood or marriage ties to, and how that has developed over the last 1,000 years, particularly in English-speaking countries, and if we've got time, Islamic countries. There are three main spheres of cooperation that people have. There's the involuntary cooperation we have through government and the state. If you're a taxpayer, or if you know someone who pays taxes, you'll be familiar with, you pay taxes, and it's obligatory, and it's put into a pot, and it's used for a whole bunch of collective activities that would not otherwise happen in some cases, or would happen, but be done a different way. But that's not the focus here, nor is the focus really on for-profit private cooperation of people voluntarily getting together as shareholders to form companies and make money, although I'm going to go through some of that as it's interesting and relevant. Mainly I'm interested in private, not-for-profit cooperation, where people who are not part of the same family still get together in organisations like this one, or communities like this one, but also other sorts of organisations and institutions whereby people have formed communities and done stuff together that they couldn't do alone. So the main institutions of cooperation privately have been the partnership, the trust, the corporation, and the waqf in the Islamic world, which is similar to a charitable trust over here. So to deal with corporations just briefly, ignoring corporations' soul, there have been, over the last 700 or 800 years, 4 stages of different ways of being a corporation, a legal entity distinct from its own members, like a university or a company or certain other types of thing. The main sorts of corporations we used to have were chartered corporations, where the Crown would publish a charter saying this is a new university or a new Royal College of Nurses or the Stationery Office and so on. And there are a couple of really old corporations who sort of operated as corporations for centuries, and the courts basically treated them as though they originally had a charter. The University of Oxford is a good example, where they just basically lied and pretended they used to have a charter, but really the courts were pragmatic and said, we'll treat you as though you used to have a charter. Since then, we've had joint stock corporations and limited liability corporations in the sort of 16th and 19th centuries, and it used to be that every corporation required a specific Act of Parliament. RBS, the bank, and the Bank of Scotland, the Hudson Bay Company, there are a lot of them, which is like a clothing retailer these days. They had to have specific Acts of Parliament to create them. And nowadays you can go to Companies House and you can just register a company for 50 quid. And all of these things require state authorisation. Either the Crown or Parliament or Companies House must specifically decide to let you assume this form and get the benefits and costs associated with that. What do you do then if you want to do something that the Crown or government or whatever doesn't particularly want to be seen to be involved with? There are certain legal purposes for which you wouldn't be able to do any of these sorts of cooperation legally, but for other things, particularly political opposition or religions that are not the main dominant religion that's associated with the state, you don't want to have to go and ask someone's permission. And it's a feature of many continental European legal jurisdictions that basically you've got to go and ask permission to get an organisation for private purposes, even when you don't need all of the things that come with that. So the main focus, if I've got time, is on trusts. there are four elements to a trust, roughly speaking. There's some assets, there's someone who creates the trust, gives the assets to a third party, some trustees, who hold those assets and own them on behalf of yet another person, the beneficiaries. Thousands of years ago, 2,000 years ago at least, the Romans certainly permitted dead people in their wills to give, say, some friends or relatives some money to hold, or lands to hold on behalf of someone who wasn't grown up yet. And it was only in about the 13th century, as a tax dodge, that it was permitted for people to give money to people who were still alive, to give assets to people who were still alive, to hold on the basis of someone else. And the effect of this was that there was a legal owner, the trustees, and a beneficial owner, the person who got the benefit of the use or income of the goods that had been placed in this trust. And so it allowed a separation of ownership and control, and that meant that you could have more efficient ways of organising, and you had a remedy in the courts if the trustees went and used the resources for something other than the purpose of the original grant or the original organisation. This started in the 1200s, and over time was embellished by the courts in England. And it's important to note here that the courts, there was a lot of pluralism. There was the common law courts and the courts of chancery, which dealt with a different sort of law, and the courts of the church and so on, that were in competition with each other. And this facilitated the evolution of this particular legal instrument. And it got generalised, and the restrictions and sort of silly things where it didn't work if you hadn't filled out the forms correctly or whatever it was, you hadn't gone through the formalities, were ironed out, and we ended up with a general mechanism whereby a group of people would get together and say, we'll take this money, give it to those people for the benefit of whoever we choose, and for that arrangement to be respected by the courts. But what's not involved here is specific pre-authorisation or authorisation at any point by the government or parliament or anything other than the courts in the event of a dispute. And so what the consequence of this was that if you were a dissenting church, or you were Catholic or Jewish or something, and you wanted to own a building and employ a priest or a rabbi or something, you could do that without having to go and get a company. In 17th century England, which was run by the Anglican Church, very closely linked to the government, you couldn't rightly go up to them as a bunch of Quakers and say, hi, we oppose the whole Constitution and think you're all heretics, and by the way, we'd like you to give us a royal charter so that we can have our parish church and employ the vicar without someone walking off with the cash. And so the institution of the trust, and it's originally a tax dodge. Its protection and recognition by the courts, despite a lot of attempt by the executive branch of government to stop it, allowed a degree of freedom of association and religious pluralism that wouldn't otherwise have obtained. And the same mechanism is used as the basis of trades unions and sports clubs. The stock exchange was a trust until, I think, the 19th century. It wasn't a company. The Tory party was an unincorporated association in the 1980s, and they were sued for masses of corporation tax. And they said, well, we don't actually exist as a legal entity. And this was during the Thatcher administration. The Conservative Party made the argument that it didn't exist as a legal entity, which it didn't, but they were still treated as though they had to pay corporation tax. And this, what the effect of having the ability of anyone in the country to get together and make organisations without permission has been that over centuries we've got lots and lots of little organisations that do things like running schools and running sports clubs and other sorts of operations. These are the little platoons, as Edmund Burke would have put it, or the big society, as David Cameron and his apparatchiks used to describe it. And there's a lot to be said for it. It's private initiative, people without having to ask anyone for permission going and doing stuff that they think is useful. It may be completely harmful to the rest of society, but at least some people thought it was a good idea, and it didn't have to be thought up in Whitehall or in City Hall or County Hall and imposed downwards and centrally. So, although it's not useful for a lot of purposes, because all the members of this organisation are liable for its debts, unlike in a corporation where you've got limited liability, it's a useful step on the organisational growth path, and in many other countries, this ability to have an organisation, just a group of friends get together and say we're going to put some money in the bank account to run whatever it is, can't do that without a lot of formalities that involve the government and potential political control and surveillance. So yeah, it promotes freedom of association and private initiative. We can compare with France, which until 1901, from the revolution until 1901, it was illegal to be a member of an association of more than 20 people that didn't have a profit-making motive. You know, so companies were, of course, permitted, but an association sans but lucratif, as it's called, was only legalised in 1901. In the reforms of, I think, Waldeck, Rousseau, whoever it was, but you know, they basically banned civil society in France until 1901. You've got to worry, what were the implications for democracy if you couldn't form a political club that could, you know, pay for a room or, you know, form a trades union or anything like that? I can't imagine it was healthy. And it's interesting that things like the Hamas Charter still ban or attack Freemasonry and the Rotary Club as though they were sort of eating out the unity of society. If I have time, how much time do I have?
We have another 9 minutes.
Another 9 minutes. 9 minutes. Okay. I'll talk a bit about the institution of the Waqf in Islamic law. I've been living in Bosnia. I was living in Bosnia for a lot of last year. And when someone originally talked about having this talk, he said, "Oh, if there's any way you can wheedle Africa in as a theme, then..." Do you remember this? You said there ought to be an African theme, but okay. I wasn't able to come up with one. But you know, the northern part of Africa is largely full of Islamic societies, and that was the sort of starting off point for including this part. But Islamic law has a mixture of some fairly good and some fairly bad things in it, and one of the features it has that's similar to the English legal system. One is the way of doing legal reasoning, the way of taking rules that we already have and combining them and to synthesise some new rule that covers a case that doesn't already exist. And for many centuries they had a completely decentralised justice system where there would be individual judges not run by a central bureaucracy, which is very different from our way of thinking about here, but a very pluralistic system. You paid a judge that was known to be impartial, and he, I think it was always a he, would give a ruling on the basis of Islamic texts or of various types of reasoning that were permitted, and the types of ways of developing the law that were available gradually changed and got politicised, and of course some problems had a big impact. But the Islamic law has a institution called the Waqf, which is similar to a trust, but it has a number of tedious restrictions that stopped it from developing to be the general purpose mechanism that's found all over bits of English law. It started similarly, effectively as a tax dodge, and the original, so these things developed about 1,000 years ago. Islam is more like 1,400 years old, and the rules that they had on taxation, and sometimes the laws are not enforced and are merely influential, sometimes completely ignored, sometimes absolutely determinative of the outcomes. They had a system where effectively there was a maximum tax rate set by religious rules, and you're only allowed to spend tax in particular ways, and this meant that the public sector could not really operate in certain domains, and it had to be provided at all by private initiative. And so a response in this environment was people could put assets into a waqf, as it was called, to found a trust or a foundation, and the assets would then be immune from tax, and they would be allowed to specify that their family in perpetuity in charge of running this thing, be allowed to run it maybe for a little bit of profit. Its assets were treated as completely sacred. The political authorities were really not likely to go after assets that were donated for religious purposes for the service of the community. So they were regarded as sacrosanct and very difficult to expropriate. So it had those sort of advantages. And they were used for a whole bunch of purposes, like there's a lighthouse in Romania that was built by Waqf, the water supply for villages, madrasas, and there's even evidence that there was a Waqf set up to provide poor women with bridal wear for getting married. And it's interesting that the Conservative Party in the UK was proposing a state subsidy for weddings because they felt people are not getting married because it's now so expensive. Let's give them some cash and then maybe get more marriages. And 1,000 years ago, there was a group of private individuals that put money away to provide for such a thing. Unfortunately, the Waqf has a number of problems with it as well, because it was a fairly serious tax dodge. The political authorities made sure that it was very restricted in how people interpreted the meanings of the original foundation deed. You weren't allowed to amend it easily, which meant that if a village just disappeared because the water had gone or the trade routes had moved, you couldn't get the assets that were for that village and transfer them to something more useful. You couldn't merge these things lest they be a rival to the political authority of someone else through the accumulation of assets. But you ended up with an environment for centuries in the Ottoman Empire and the Abbasid Caliphate where people provided for a whole bunch of things that could be provided for by the state or by for-profit corporations by effectively perpetual charitable trusts set up for really narrow purposes, like one water fountain or something. And I think it's just an interesting point of comparison and it has many similarities with the English law environment that we have. So, what, if anything, is to be done about the current situation that we have today? Beneficial ownership is under attack across the West. Being the beneficiary of a trust means that you are suspected of some kind of tax avoidance or of trying to hide your assets or involved in something. Now, of course, there are all sorts of good reasons, and some of us would say you don't even need to justify this, but certainly investigative journalists and others think of this as just a bad idea. And they want a registry of property that's held in trust. And registration, of course, implies the involvement of a central authority, which would undermine one of the great advantages of these arrangements, which is that they are done by the parties amongst themselves without involving the government or authorities. In many jurisdictions, we've got dedicated legal forms for particular types of non-profit organisations. This is not a problem we have in the UK, but it is starting to become a problem. In the UK, you can have a company, you can put its shares in trust. Like I think the John Lewis Partnership works a bit like that. In many countries in Eastern Europe, there's a specific type of entity that you register as a non-profit organisation. So the government's got a list of them, and when it wants to go and round up all the people who are funded by foreigners, well, they know where to find them. And certainly they were very interested in my list of people who'd received money from foreign donors. I used to work in aid transparency, and the Bosnian government was very interested in, you have a list of all the foreign-funded NGOs in our country. They were more interested in fighting terrorist finance, but it was an interesting angle that some of these transparency concerns start to rub up against an old and not well understood institution. And you'll all be familiar with the sorts of things that the Charities Commission is doing in relation to civil society organisations. I believe it's getting better, but I don't track this space anymore. And the final problem, I think, is, and this is a view shared across the political spectrum by some people. It doesn't really cut across the normal conventional lines. There's a lot of money from taxpayers going into charities to the point where really they're implementing government policies and aren't the sort of autonomous things that they were founded to be. And that has all sorts of problems, and it undermines many of the benefits of paying taxes and many of the benefits of these things being independent of government by mixing the two things up together. And I think that's fairly problematic. So I don't have a summary or a conclusion, but I would say that the the way that these things have evolved, these particular institutions, the trust in particular, and the corporation, have enabled unexpectedly the freedom of association and the ability of people to work together without requiring lots of assistance from other people. Just these practical things about making sure that your treasurer doesn't walk off with your cash have been the results of lots of little individual evolutionary steps in court cases over hundreds of years, different people in different times pushing for a particular thing. We've evolved and polished and perfected these institutions, and we need to make sure that we're not going to mess them up accidentally as they provide a space of private collaborative activity that benefits everyone. Thanks very much.